ngasiyona ingxenye yalabo ababephakathi ke endlini ke bona ke ngaleso sikhathi ke ekwakungekho isiqiniseko nokuthi bakhuluma iqiniso noma cha kodwa ke lana sithola abantu abawomakhelwane bayasho ukuthi ngempela kunabantu abagijima baya ngakho uhlangothi sinamaphoyisa amabili afika ke khona lapho nawo atshelwa ukuthi cha kunabantu abaphumileke endlini bagijima baya ngakuhlangothi oluthize.
Thank you. Now, Brigadier, if we can now deal with accused number 2.
Sorry, before you start, I'm sorry. You said neighbors. There was a neighbor you said in the evidence. They say that neighbor passed away. It's Mr.
Ngasha. Yes, yeah, the senior.
The senior. Was he a policeman or what?
He was a warrant officer, was a police officer, yes, and then he retired warrant officer, yes. He disposed an affidavit and also the same indication was given, my lord. Yebo kunalo baba ke owashona ke uNqatshe owayeyiphoyisa ke noma owayeyi-warrant officer ke ngaphambilini naye une statement ayesenzile ke esho khona lokho. And my lord, further one can say that in dissecting this, because at that stage it was almost like a fact-finding mission for me, because you see with this matter there are sort of two, you have obviously what is contained in the docket, but there seems to be this theory or assertion or allegations, if I can put it that way, that there were no intruders. One needed to dissect what was contained in the docket factually, not on allegations or theories on hearsay, on the facts that were contained in the docket. And the facts contained in the docket, my lord, indicate what I've informed the court, that there were independent witnesses other than the people who were in the house who saw people running out of that house. No one could say that the people who ran out of the house were actually the same people who were in the house. They ran, a description is given by the neighbors who were outside. That description, particularly of one of the shooters with the dreadlocks, is also given by the people who were inside the house. So there you find a common factor that there was a person described with a firearm inside the house with dreadlocks. The neighbors, particularly the lady that was sitting outside, I recall that saying she saw when they were running away that one of the suspects had dreadlocks. Now, you have to take that objectively, my lord, not in terms of hearsay, objectively. In addition to that, my lord, I've said objective evidence, which is DNA, that was found at the crime scene, excluded everyone that was in the house. What it indicated is that that DNA was left by someone else other than the person who were in the house, the persons who were inside the house. That DNA was obviously at a later stage, my lord, when these accused were actually now targeted. Their DNA were taken for comparison. I suppose when we get to that stage, I will deal with it, my lord, because as much as certain findings were made by the specialist, but they were pointers by the specialist to say there are common things that you can find on these people. And for me as an investigator, it was good enough that even if it's 1 or 2% of the DNA, for example, pointing accused number 3, it is enough for me to convince me that he was there as an investigator.
That is not his terrain. It is exclusively not his terrain. He's repeating the very same thing that I cautioned about. Mr. Gininda is not here as an expert, man. He's here as a police officer. He only needs to bring information to the court, the basis on which this court then will have to make a decision. He is not here to analyze that information as though he's the one that is going ultimately to give a judgment. He's pretty wrong, and the state is allowing to do that. I don't know if the state is doing that with a view in order to influence the mind of the court, but I'm very grateful because the court said earlier on that the court is well trained and it is experienced enough to separate the wheat from the chaff. What Mr. Gininda is doing now is only trying to influence the mind of the court with a hell lot of a chaff. What is stating that it's a chaff is nonsensical. It should not be done, my lord. And I'm going to request the state to tell its witness to refrain from what the state's witness is doing, my lord. Because it's not here as an expert, and we're not interested in his opinion. His opinion matters not. Ultimately, it is going to be the duty of the state, on the basis of the evidence that Mr. Gininda would have submitted to this court, to argue what he is now trying to argue. Otherwise, Mr. Baloyi needs to get into the box, and Mr. Gininda coming to the point where Mr. Baloyi is standing. They need to swap positions. But what he's doing now is pretty nonsensical, my lord.
Okay, yes, let's hear the state. That's the state's
As a case, my lord, I think very fresh on the article that the court referred to about courtesy in court. One would have expected Advocate Mxolisi to refrain from using words such as nonsensical, no matter how strongly he might object to the evidence. I think there's still a duty to show courtesy to the witness and the court. That is the first thing. The second thing is the court had asked this witness a question in elucidation, and the witness was in the process of answering the question that was posed by the court. And thirdly, as Advocate Mxolisi pointed out, that the court has mentioned that it's trained to separate evidence from opinion evidence.
Usingeneke kulolu daba-ke ukuthi-ke ufakazi besaphendula-ke umbuzo inkantolo ubuzile esho-ke ukuthi-ke kwakuney'nkulumo-ke eyayikhona-ke lana futhi-ke kukhona-ke nale information eyayikhona-ke kwidokodo okwami-ke kwakuwukuthi-ke manje-ke ngithole-ke ekuyikona kodwa-ke ngingalandeli iy'nsolo ey'khona noma iy'nkulumo ey'khona-ke ukuthi cha abekho abantu ababengenile laphayana kodwa-ke ngibheke lokhu okukhona-ke kwidokodo bese-ke manje-ke ngibheke nalokhu ukuthi cha akunabantu-ke ababengenile manje-ke unabantu ababesendlini-ke abashoyo ukuthi omunye wabantu ababephakathi-ke endlini nama-dreadlocks ekwakuyena-ke wayephethe isibhamu ube nabo omakhelwane abathi-ke kulabo abantu abababona-ke bephuma endlini-ke ukuthi-ke noma sebegijima-ke noma bebaleka beya kuhlangothi oluthize omunye wabo wayenama-dreadlocks aqhubekeke futhi esebenziseke ukuthi kwakufanele manje ngibheke-ke ukuthi-ke manje kulokhu okhulunywa yilabantu-ke kuyinhlangothi ezahlukene uthi-ke kwabe kusekhona nalo bufakazi-ke bolibefuzo noma-ke phecelezi-ke i-DNA wabe esenza-ke ekhuluma-ke ngaye umsolwa-ke wesithathu ekula ummeli wakho asukume khona-ke ethi asithi-ke mhlambe bekukhona-ke okwatholakala laphayana kwi-DNA leyo noma-ke u2% kumina noma u1% kodwa nje okusho ukuthi yebo-ke wayekhona-ke wabe eseshoko ukuthi asithi-ke mhlambe umsolwa-ke wesithathu ekula ummeli-ke asukume khona-ke ukuthi nje lokho loyo 2% kumina-ke wawaneleke ukuthi ngisho ukuthi yebo impela wayekhona lapho.
Thank you. The state will request that those gratuitous and unbridled insults by Advocate Mxolisi regarding the witness be ignored, my lord.
There is no insult. The word nonsensical is there in the dictionary. If Mr. Baloyi is not aware of it, I can refer him to that word. And the definition of that word simply means that it makes no sense. It is nonsensical. I don't know how insulting that word is. Right? And I heard him mentioning that there's an article on a Sunday that he read regarding court ethics and stuff like that. That starts with him. He knows what the duty of a witness who is an investigating officer is when that witness is giving his evidence. It is Mr. Baloyi's duty, first and foremost, as a leader of that witness, to lead that witness specifically on what that witness should come and tell this court, not to allow that witness to be on an escapade and wantonly come and give evidence that it is not in his terrain to come and give. Mr. Baloyi has been allowing Mr. Gininda to give opinion evidence. Mr. Baloyi has allowed this witness on a number of occasions to come up with suggestion that the evidence that is already before court demonstrated that accused number 3 was involved in this matter. He now mentions DNA. Previously also mentioned a firearm. It consistently allows this witness, my lord, to go on an escapade on evidence that it's, at this stage it is inadmissible. It's basically giving this witness a role that he himself should actually be playing. For instance, the court has simply asked a question about Mr. Ngachi, whether or not he was still alive or what. This witness now goes out of the rail. It goes out of the question that the court has specifically asked. And Mr. Baloyi allows that to happen. And then he stands up and says there's an article that has been written by the honorable judges of this court on how ethics is. I am not here, my lord, representing myself. I am here to represent the interest of accused number 3. And I cannot allow witness such as evidence such as the one that is coming from Mr. Gininda to go through the record and miss it down here. I'll never allow that, my lord. Otherwise, I'll be doing injustice in the representation of Mr. Mncube here. But first and foremost, it starts with Mr. Baloyi himself. Okay. Thank you, my lord.
To save time, my lord, we'll then proceed. I've already mentioned that the witness was commenting on the question that was asked by the court. We had already moved to the situation of accused number 2 when the court asked this witness to comment on something. We cannot interrupt the witness when he answers to a question that was answered by the court and to which the court is entitled to ask. That is the simple fact of the matter. And as we pointed out, my lord, we don't understand the objection that was raised by Advocate Mxolisi as the court pleases.
I will make declarations and conclusions regarding the evidence tendered in this court, whether that evidence proves or disproves anything. And I'll quote the reasons why, if I agree or disagree with that evidence. Okay.
Thank you. ukuthi-ke ubufakazi obethulwayo-ke lobo bufakazi buvumelekile noma cha ngizosho futhi-ke nangokomthetho ukuthi umthetho uthini mayelana nalokho.
As the court pleases, my lord, I agree with the court on that it is the duty of the court to analyze the evidence, my lord, at the end of the case. However, my lord, I'm also standing on the point of objection so that it will go on record that it was pointed out, my lord, during the trial stage that the way that the evidence is elicited at this point in time is not the correct procedure, my lord. Especially, my lord, the reference that has been made by the witness to the Ngashe senior witness, my lord. That statement was never handed in this court. There was no application for the handing over of that statement as hearsay statement. So in other words, my lord, it is not proper before this court. and the witness has made reference to the content of that evidence.
Yeah, no. Where do I get the evidence? I got the evidence here.
Yes, my lord.
When I came to know that there's a neighbor who has made a statement, who actually also had the commotion, and there's another neighbor also who saw the deceased with his back in a white skipper or sweater,
Yes.
in the kitchen and had commotions. Somebody jumped into the yard and ran outside again. But the evidence of being a policeman who was there, I heard it from here. Am I right or wrong? I mean,
Yes.
how would I know otherwise?
For the one for the police, my lord, I don't have objections because those police testified.
No, Tetra and that gentleman, I don't have a problem.
Yes, my
I
lord.
mean Nashe.
Nashe,
Because
yes,
I wanted
my
to
lord.
know where Nashe is.
Yes.
And I was told that he's deceased.
Nashe is deceased, my lord, and his statement was never submitted to this court as evidence, my lord. And therefore, no reference should be made to that statement or can be made to that statement, my lord.
When you say no reference should be made to that statement, no reference should also not be made to the evidence of the son of Nashe. What's his name, by the way? Kaya said, I was with my father. You remember that evidence?
My lord, the son is alive. The son has testified.
You don't know what I'm getting to, you see.
Oh, sorry, my lord.
The son also spoke about the father,
Yes.
having seen whatever.
Yes.
That's all. And then the
Yes.
father is dead.
Yes, then let's correct the record, my lord. If we are making reference to the evidence of the Nashe's son, then it must be directed to that portion of evidence that Nashe's son said 1, 2, 3, 4, and 5.
Okay.
But reference being made to the statement made by Senior, who passed away, and his statement has not been submitted as evidence. My lord, I'm raising an objection
Okay,
on that
fine.
point only.
Fine, okay.
Yes, my
Let's
lord.
go on.
And then also, secondly, on the issue of this witness giving analysis or making reference to the expert evidence, my lord, which is the forensic evidence which was led in this court, who is now saying, out of that expert evidence, I can be able to say 1, 2, 3, 4, and 5. He's not an expert, my lord. He's not allowed to make any reference and to analyze on that part of evidence. He's just a police officer, this one. As the court pleases, my lord.
All right, yes, Mr.
As a court pleases, we really don't, the neighbors that the brigadier is referring to have already testified, Ms. Nthabise Mokete as well as Ms. Kaya Ngashe. The evidence is already on record. As far as the analysis is concerned, the witness is merely saying that those are, the expert has already testified. The DNA analyst has already testified. The witness is merely giving a summation of the reason why he was persuaded that there were no, that there were intruders. That's the simple fact of the matter. But as we mentioned, my lord, we were busy commencing with the evidence pertaining to accused number 2.
Sizondlula ke manje lapho sizoqala ke ngobufakazi ke mayelana naye ke umsolwa wesibili.
Right. Now, Brigadier Ugininda, you've already confirmed your testimony in the trial within a trial, in which you also testified about the circumstances under which accused number 2 was arrested.
That is correct, my lord. But if the court can give indulgence, my lord, I just want to say, and I'll request the court, perhaps, my lord, to assist in that what was said by Advocate Mxolisi, because that's exactly how I'm viewing it. It is insulting. For him, the word nonsensical or nonsense may mean something else if he interprets it. But I think the context of how it's said may give a different meaning. I feel it's insulting and disrespectful. I don't think I've done anything contrary to being respectful to Advocate Mxolisi ever since we started to deserve that. And I just want to request that we maintain the decorum of the court. We may differ with what I say. He will have the opportunity when he cross-examine me as to why I said that, why did I base those expertise, and challenge me on it, my lord. And the court will then make a ruling. I was simply making my observation, not testifying as an expert, to say these were the pointers that convinced me that they were intruders. Not that I was saying, my lord, the expert or whoever did the work were wrong or right. I was simply saying, after the matter was given to me, I had to analyze and make a decision as to whether indeed there were no intruders or were there intruders. And if there were no intruders, my lord, I would have given the same evidence to say, this is what I have, this is what the DNA is saying, and based on that, I was then convinced that there were no intruders. But in this instance, I'm simply pointing things that convinced me that they were intruders. Not that I'm reinterpreting or testifying on behalf of the expert. It's simply that, my lord. But the mere point of my statement, my lord, is just to request that we treat each other with respect. That's all, my lord. The difference is, I know we will bump head with my colleagues because we're on the opposite sides. But at the end of the day, it's nothing personal. It's in the interest of justice and to help this cause to come to a just conclusion, but not to treat each other with disrespect. That's all I need to ask, my lord.
Engizocela ke ukuthi ke mhlambe ingaba yona ke inkantolo engangilekelela ke noma ke ukuthi ke kwenzeke ke lokho ukuthi ke ngicele ke ukuthi ke kube khona ke inhlonipho ngoba ngendlela ke akhulume ngayo ke umnumzana ke uMnisi ke ngegama ke lelo albizile nonsensically ke mhlambe yena ke angalihumusha ke ngendlela ethize kodwa mina ke ngihumusha ngendlela ethize kodwa kumina ke kubonakalisa nje ukuthi ke ungabi khona kwayo ke inhlonipho akukho ke sengikwenzile kuzofinyelela khona manje okungathi ke kuholele kuthini ke mina ngimhloniphile noma angenza ke lokho mina ebengikwenza bengingaphikisani nobufakazi bakhe ke ungoti mayelana ke nolibofuzo noma ke iDNA bengichaza noma ngiveza nje ke izinto ke ezibe khona ezibeyinkomba kumina ukusho ukuthi yebo babe khona abantu abangena kuleya muzi noma kuleya ndlu noma ke bekuwukuthi babengekho ke bengizonikeza ke ubufakazi obufanayo ngithi yebo ke ngenxa yalokhu ke ngithola ke ukuthi cha abekho ke abantu ababengenile kuloya muzi ukucela nje ukuthi ke nje kube khona ke nje indlela yokuhloniphana la enkantolo.
Okay, enough said. Can we adjourn for tea? I'm told it's 20 past.
Oh, okay, it's a good place.
Okay.